Today, we're tackling a question that, if you live in an HOA, you've probably wondered about. How much can your board really get away with? We're going to dive into this whole idea of governance versus secrecy, and we'll do it by looking at one heck of a legal fight. I mean, really think about it. Can your board just decide to hire a brand new, more expensive contractor or, I don't know, spend tens of thousands of your dollars, and you don't hear a peep about it until it's already a done deal? Well, let's find out. Okay, so here's how we're going to break this all down. We'll start with how this whole thing kicked off. Then we'll look at the case against the board, but also hear their side of the story. We'll even dig into the actual law, see what the judge had to say in the end, and, most importantly, what it all means for you. So let's set the scene. We're in a community in Arizona called Cielo Noche. And this whole thing starts when one homeowner, a guy named James Dutton, files a formal legal complaint against his HOA board. This wasn't just a cranky email. This was serious. And here's the thing that really makes this story fascinating. Mr. Dutton wasn't just some random homeowner with a grudge. He was the former president of that exact same board. So, he knew the rulebook inside and out. And he was basically saying, hey, my old colleagues, they're breaking the law. So what was the board supposedly doing that was so wrong? Well, Mr. Dutton's complaint wasn't vague at all. He laid out a bunch of very specific decisions that he claimed were made illegally, behind closed doors. Take a look at the timeline here, because the timing is, it's pretty wild. Literally the day after Mr. Dutton resigns, the board holds its first secret meeting to talk about a huge $100,000 settlement. And that just kicked off this whole pattern of making these massive decisions in private, leaving all the other homeowners completely in the dark. And let's be clear, we are not talking about small potatoes here. This isn't about deciding what color to paint the mailboxes. We're talking about a six-figure legal settlement, hiring a new management company that costs more money, and bringing on a landscaper that eats up a third of the entire yearly budget. These are huge decisions that hit every single homeowner right in the wallet, and they were all happening in secret. Okay, but every story has two sides, right? The board wasn't just going to roll over and say, you got us. They had a defense. They argued that what they were doing was totally above board. So how did they explain all these secret meetings? Basically, their whole argument boiled down to two words: executive session. They claimed that the stuff they were discussing fell under these special exceptions in the law that, allow them to meet privately for confidential matters. In this slide right here, this gets to the absolute core of the disagreement. For every decision made in secret, the board had an excuse ready. When they were called out for hiring a new management company, they said, oh, we were just discussing the poor performance of the old one. The big settlement? Oh, that's pending litigation. The new landscaper? Same deal, discussing a vendor's performance. So the big question for the judge was, do these excuses actually hold water under the law? All right, so to figure out who's right, we've got to look at the rule book itself. Let's dig into Arizona's law on HOA meetings and see what it actually says. So the law starts with this really clear, really powerful default setting. It doesn't say, some meetings should be open. It says all meetings of the board have to be open to all the members. Transparency isn't just a nice idea, it's the rule. But, of course, there are a few exceptions. The law does allow for these closed private sessions, but only for a handful of very specific reasons, like getting legal advice from a lawyer, talking about a lawsuit that's either happening or about to happen, or discussing the performance of a specific employee or contractor. And that is the loophole the board was trying to squeeze through. But here's the kicker. This is the part of the law that changes the whole game. The law itself has a tiebreaker rule built right in. It says that if there's any confusion, any gray area at all, you have to lean in favor of an open meeting. The law is clearly designed to protect homeowners, not to give boards a way to hide things. So, we've heard the accusation, we've heard the defense, we've looked at the law. Now for the main event. What did the judge decide? And the verdict was a decisive win for the homeowner. The administrative law judge looked at everything and came to a simple conclusion. The Cielo Noche board had, in fact, violated the open meeting law. And this quote from the decision really says it all. The judge basically said that the board's reasons for going into these private sessions just weren't good enough. Using performance issues as an excuse to secretly hire a whole new, more expensive company without telling anyone, that didn't fly. It just didn't meet the law's very narrow criteria. Now, the board didn't get slammed with some massive fine or anything, but the judge did order the association, which, let's be real, means the homeowners themselves, to pay back Mr. Dutton's $500 filing fee. And what that does is it puts it on the official record. The board was in the wrong, and the homeowner who called them out was in the right. Okay, so a homeowner in Arizona won his case and got his $500 back. Big deal, right? Well, what does this actually mean for the rest of us living in HOAs? What's the real lesson here? What this story really does is it gets to the heart of the balance here. I mean, yeah, a board needs to be able to get things done, but that efficiency can't just steamroll the rights of homeowners, the very people the board is supposed to be serving. So here are the big takeaways for you as a homeowner. Remember, open meetings are the default, legally. Those private executive sessions are supposed to be the rare exception, not the everyday rule. Big money decisions about vendors and finances, those should almost always be happening out in the open. You have a right to be there and a right to know what's going on. And that really leaves us with one last thing to think about. After hearing this story, it's worth asking yourself, how transparent is your own board? Are the big decisions happening in a room you're invited to, or do you just find out about them after the fact? It's a question worth asking.